Hi Cyber Law Class, it's Professor Opterbeck. Welcome to week 5, and this week we are going to talk about cyber law, computer crimes law in the EU, and we will also talk a bit at least about the nature of cybercrime outside the West, and particularly coming from Russia and former Soviet Union countries. So with that, I want to give you a little bit of background from some of the materials that I gave you to read, and those materials included the most recent Europol Internet Organized Crime Threat Assessment, and which was produced in 2020, and I'll get to that one in just a moment. First, I want to note some things from the 2018 Europol assessment, which I am not requiring you to read right now. If you want to, you can look it up on the Europol website. But I wanted to focus on a few things in that one because it gives a lot of good information about the problem of ransomware. And you can see in the 2020 assessment, the most recent assessment, that ransomware remains a major problem for European authorities. And the 2018 report talks about some very large, some very significant ransomware attacks that happened in 2017. And if you're looking at these dates, you can note that the focus of this report is on ransomware attacks that occurred before the COVID pandemic. And understandably, the current report focuses a bit more on issues that arose during the COVID pandemic, which included ransomware attacks as well. But if you remember some of those times, some of those attacks in that period before COVID, 2017 was the WannaCry attack. The WannaCry attack used an exploit that had been created by the US National Security Agency and had been stolen by a hacker group called the Shadow Brokers. And it affected a significant number of countries throughout the world. And you can see in this map from the 2018 Europol report some important areas in the EU that were hit with that ransomware. And something you can note from this is even before the pandemic, healthcare providers and health insurers, so the UK National Health Service, some hospitals in some parts of the world, were already important targets for ransomware. So it shows the vulnerability of the healthcare system to ransomware, which was only exacerbated during the pandemic. There were claims that the WannaCry exploit was launched by North Korea, and there were some patches issued shortly after the attacks, but even with those patches issued, it caused a lot of problems. And then also in 2017 were the Petya and non-Petya ransomware attacks. These, at the time, and I think this label still applies, were considered the most destructive cyber attacks in history. So they were very significant. Also a variation on this NSA exploit. And you might ask, well, why does the NSA have these exploits, the US National Security Agency? The National Security Agency and other national security agencies in other countries collect zero-day vulnerabilities, collect exploits that they may use in their espionage and information gathering activities. And they also collect them to study them in the event that some bad guys launch an attack using these zero-day exploits. So governments are involved in collecting these. Governments are involved in using them. In this particular case, the information that the NSA had got out. So the attack began in Ukraine and widely believed to be an effort by Russia really to conduct cyber war against Ukraine. But the attack got out from Ukraine, escaped from Ukraine, and it spread, and it caused a lot more damage, a significant amount of damage throughout the world. The there was a patch, the WannaCry patch, as I mentioned, was issued by Microsoft. Zero-day exploit, to step back for just a second, is a vulnerability very often in basic software like an operating system. So it could be a vulnerability, for example, in the Windows operating system that is not yet publicly known. If it's publicly known, if Microsoft, for example, knows about a vulnerability in its operating system, it will issue patches that close that vulnerability, and then users are able to close the gap, and the exploit should be, if not stopped dead in its tracks, at least slowed down. The problem is if users don't do the patch, so patches get pushed to your system by a company like Microsoft, but as a user and as an enterprise that is a user of something like Windows, you have to roll that out and accept the patch. And if you're not accepting the patch in the updates, you're putting yourself at risk. You're putting your system at risk, because very often those updates, in addition to adding features or fixing just sort of annoying user-related things, they close vulnerabilities. Further, a lot of the machines and systems that were exploited were using previous versions of Windows which were no longer supported by Microsoft. And really a key part of support for something like an operating system is rolling out patches when vulnerabilities are discovered. And as a legacy system becomes deprecated, as it's no longer used, the provider, Microsoft in this case, will at some point announce that they're not issuing patches anymore. So if an entity was using an older version of Windows, which really was not uncommon, then it was quite possible to have not received the patch, and therefore to be vulnerable to these further variants of the Eternal Blue exploit, which had morphed from WannaCry to then Petya and non-Petya. Another example from 2017 was the Bad Rabbit malware, the Bad Rabbit ransomware. This screenshot is actually a screenshot from how the Bad Rabbit ransomware would look if you were looking at it from an infected network. These were often implemented through what are called drive-by downloads. So I said before, you want to make sure that you are patching. You want to make sure that you're updating and you're receiving the things that the manufacturer or the proprietor of the software is rolling out. You do, however, have to be careful that what you're installing is in fact a true update, a true patch, an authentic patch from the supplier. In this case, many instances of Bad Rabbit were downloaded when a pop-up window would appear to update Adobe Flash Player. And people would click on this, and in fact it was not an update for Adobe Flash Player. And this is, you might on the one hand say, well, that's sneaky, that's tricky. If you're supposed to patch, how would you know? One of the issues there was that Adobe Flash itself as a program was being deprecated. So there would really be not much of a reason to update it. There are other technologies that are really being used to play. What Flash did was to play video through web applications. So you need to know enough, or someone in your organization needs to know enough to do updates and patches, but also needs to know enough about what are legitimate updates and patches that are being rolled out by the supplier. This particular piece of ransomware primarily were victims in Russia and the Ukraine, and it primarily focused on critical infrastructure, healthcare, transportation, finance, which leads investigators to believe that this also was probably a variant of cyber war in the war between Russia and Ukraine, most likely developed by Russia. So let's look now at the Europol 2020 Internet Organized Crime Threat Assessment, and note the top threats that are reported in this report, in this assessment. The top threat, once again, is ransomware. And once again, the report notes the top threat of ransomware being to supply chains and to third-party service providers. So ransomware continuing to focus on things that we can call critical infrastructure, and ransomware also disrupting the sort of intermediate place of the economy, the place of supply that is getting things out to retail. Malware, according to the report, remains a major threat, and of course malware is connected to ransomware because ransomware is often delivered by malware. And I do want to show you the one piece of the malware that's mentioned in this report, because the report is noting that the threat of malware is becoming more and more difficult because of the sophistication of the malware that is available pretty easily and pretty cheaply to just about anyone. And it's talking about malware being made available in modular packages on the dark web. So even you or I, if we wanted to, which of course we don't, if we wanted to commit some kind of cybercrime, we could go on the dark web and get a package like the Emotet malware, which is put out by a collective of the same name. And I want to show you a website that describes what the Emotet malware is, and this is from the Center for Internet Security, which is a really good center. Then the third piece that the Europol 2020 report is noting is a continuing major problem is CSAM, child sexual exploitation materials. And the report notes how there was a significant surge in the distribution of these materials during COVID. And it also notes the really disturbing trend of live streaming of child sexual exploitation and abuse, kind of going mainstream, kind of becoming a new business model. So a few of the other details I just wanted to highlight for you in the Europol 2020 report. Social engineering, the report notes, is becoming more sophisticated. The phishing, smishing, which is SMS message-based phishing, is becoming more holistic. It's becoming more competent in the use of different kinds of tools and vulnerabilities, which relates to the ability to obtain modular malware packages on the dark web, but also becoming more sophisticated about the social engineering itself, about the false identities that are being adopted by people running these social engineering attacks so that it looks like more of an authentic message, and the level of cooperation in different groups of cyber criminals in constructing social engineering attacks. There's a couple of themes in this report that the Europol report has noted for a number of years running, and these are really not unique to Europe. And in fact, I would say, and we will see through this middle part of this semester as we begin to talk more and more about civil rights and cyber civil liberties. The themes we're going to look at now in the Europol report are common law enforcement themes in the US and in Europe. So there's really a sort of a common purpose or a common set of interests in law enforcement internationally, certainly within the US and Europe. They are also, at the same time, themes that raise significant concerns for civil liberties. And one of these themes is the growing use of cryptocurrencies to facilitate payments for cybercrime. And this is in a couple of ways. So ransomware, very often, predominantly, the pirates who are holding something for ransom, holding data for ransom, demand payments in cryptocurrencies. Likewise, purchasing malware packages on the dark web or purchasing dumps of data like credit card numbers and social security numbers and so on that have been obtained by cyber criminals. Payment in those forms is often made in cryptocurrency. So because cryptocurrency is difficult to track, because cryptocurrency is not tied to any specific national currency and is not tied to international banking laws that require, at least nominally require, banks to report activity that they believe is related to fraud or money laundering, cryptocurrencies have an important role to play in cybercrime. And law enforcement authorities in the US and in the EU are calling for some kind of greater regulation of cryptocurrency. Of course, advocates of cryptocurrency argue that these are not by any means the only uses of cryptocurrencies, that there are many legitimate uses of cryptocurrencies, and that over-regulating or building in some kind of electronic tracker into cryptocurrency would really undermine the whole system of cryptocurrency. And this is a real tension point in law and policy between law enforcement and advocates of cryptocurrencies. Likewise, the question of encryption, and we're going to spend a whole class in a few weeks talking about the unique challenges that encryption presents relating to cybercrime and civil liberties. So the ability of cyber criminals to deploy encryption in things like ransomware attacks is one piece of this, and that is the classic modus operandi of a ransomware attack. How are you holding the data hostage? You have access to it and encrypted it, and you're only going to hand over the decryption key if the ransom is paid. So this is one problem. Now you could kind of respond to this problem as law enforcement by saying encryption should be in some way more heavily regulated or more trackable, or there should be publicly available decryption keys that law enforcement could potentially use to, at least with certain encryption algorithms, to open up the material that's held for ransom. That's not really the best solution. It's kind of widely acknowledged. I mean, the better solution, of course, is for the organization to be prepared by having redundancy, so that if data is encrypted, you have backup sets of data. So that's one possibility. The more important question for law enforcement with encryption is the ability of cyber criminals or suspected cyber criminals, as well as terrorists, to communicate with each other on encrypted channels. And this could include chat apps like WeChat or apps of that sort that use end-to-end encryption of communications, and it can also apply to the dark web itself, which is usually accessed through encrypted browsing. So law enforcement wants in some way to have restrictions on encryption technology or government backdoors or something along those lines. Civil liberties advocates argue that's a terrible idea, because acknowledging that encryption is used in cybercrime, it is also widely used for very legitimate and important purposes. It's used for economic purposes, which include protecting trade secrets, keeping the details of a transaction secret from competitors, legitimately so, but also for civil society groups who are working in repressive regimes who want to keep their discussions confidential, and or for any ordinary individual who simply wants to protect the privacy of their everyday conversations. And then cryptography experts argue that many, if not all, or most of the proposals to affect encryption in relation to cybercrime would really effectively destroy encryption. If you have a public decryption key, what that really means is you have a very weak encryption algorithm. We will come back to that when we discuss encryption, but notice that this is a part of this Europol report. It is a common European and American issue. similarly also the question of bulletproof hosting, BPH. So bulletproof hosting is the idea of a web host that is set up and designed for web providers who want to be as impervious as they can be to law enforcement. And that will include encryption type tools for the communication going over that host. It will include the host itself not cooperating with law enforcement to the extent that the host doesn't have to, so not voluntarily cooperating. It will include the host accepting business from persons and organizations that are on different blacklists that governments would rather not have hosts deal with. And it will include the hosts themselves being set up in locations in parts of the world that make it very difficult for law enforcement in Europe or in the US to get access to information about their subscribers. So again, this is a real point of tension between some civil libertarians and law enforcement. Law enforcement wants to be able to have some degree of access with web hosts, with ISPs. So civil libertarians argue that yes, criminals use these kinds of services, but as with encryption generally, there are important civil society and economic uses for it. I give you a couple of articles to look at on places that are known to be hubs for cybercrime. Romania, and one on China, and one generally on Russian-based organized crime. And a few themes that I hope that you see in these articles. One is that the places that tend to be cybercrime hubs are places that have good technological infrastructure. It's tough to be, to do cybercrime from a place with no high bandwidth internet access. There are places where there are skilled people and educated people. Now, a lot of cyber criminals and a lot of computer experts are mostly self-taught, but they're people with a certain set of skills, and they're often people with a certain degree of education. Law enforcement in these places tends to be lax, or at least to turn a blind eye to cybercrime, and that can be for any number of reasons. It can be because they are understaffed, but it can also very often be that the local political class is cooperating with and encouraging the cyber criminals because of bribery, because of extortion, and because in some cases the cybercrime networks may be actually connected more broadly with the national government. Sometimes in places where cybercrime flourishes, there's otherwise economic state of downturn, if not depression, fewer legitimate working opportunities, fewer opportunities to make a living wage, or to have the possibility of making extra, and so cybercrime is attractive in that way. The Crim Intern article that I gave you from the European Council on Foreign Relations, I wanted to give you some material that talks a little bit more about Russian-based organized crime. And by Russian-based, they're really talking about not necessarily just Russia, not necessarily just Russian-speaking persons, but people who are connected with the countries that were formerly part of the Soviet Union. And note that the article discusses the connection between some of these Arbok groups and the Russian state security apparatus, the Foreign Intelligence Service, military intelligence, the Federal Security Service. And if you follow a little bit U.S. cybercrime enforcement from the FBI and the Department of Justice, you'll see that officers in these groups have been indicted in the U.S. for cybercrime attacks. Now, none of those people who are indicted are ever going to stand trial because they won't be extradited. But the Justice Department, in doing that, had been trying to make a point that Arbok crime, cybercrime, is connected with the state security apparatus. And it is cyber, but there are other kinds of crimes that Arbok groups are involved in, including the drug trade and including money laundering, often connected with the drug trade or connected with cybercrime. So some groups that you may have come across and that you will likely come across in our reading: Fancy Bear is one of those groups. Cozy Bear, of course the bear is the symbol of Russia. And these are very well-known groups that have been connected with the Kremlin. And then various other freelance groups and sometimes the dynamic here is that you've got freelance cyber criminals who are kind of making their own living through cybercrime. They come to the attention of the Kremlin, and they are in regions in which the Russian security services have jurisdiction, or in regions outside their immediate jurisdiction, but which are still sort of physically reachable. And it's a protection racket. The Kremlin enlists these groups to work on behalf of the government in return for protection, that is, in return for not being prosecuted and or in return for not suffering physical violence. I thought this graphic in that report was particularly interesting in showing, at least from the data available to the people who produced that report, the locations in which there are kind of hubs of Arbok crime that is then spreading out into other parts of Europe. So, notice that you've got St. Petersburg, Kaliningrad, Riga, these places connected with former Soviet countries, Odessa as well. But you have other places, Stockholm, Berlin, Istanbul, that are not former Soviet countries, but in which the report suggests there is a significant amount of activity by these Arboks in Arbok groups. And that includes both things like attempted coups and assassinations, as well as cyber attacks. So these are some of the problems identified in the materials I had you read, and there are of course many other materials where you could see these same kind of problems highlighted. They're problems for Europe specifically because of this proximity to Russia, of course, which is really historically part of Europe in many ways, and in many ways not. But there are also problems, of course, for the United States because all of this crime flows into and affects the United States as well. So we have looked in some detail already in our class at U.S. computer crime law, and now want to spend some time looking at the materials I gave you to read on EU computer crime law. And we're going to do a little bit of comparison between the U.S. Computer Fraud and Abuse Act and the European Cybercrime Directive. Before we do that, however, I want to give you a little bit of background for those of you in the class who aren't familiar about how law is made in the EU. We talked a little bit about how law is made in the U.S. We talked a bit about the U.S. Constitution. We talked about the three branches of the U.S. government, the legislative, executive, and judiciary. We talked about the legislature having, at the federal level, the House and the Senate, who produce a text of a piece of legislation that goes to the president, and then the president must sign it to become law. And then we also talked about the vertical relationship of the U.S. federal government to the U.S. state governments, and how the states can have their own areas that they legislate and regulate in, and how the law of preemption deals with the possibility that there might be conflicts there. So what are the kind of analogs? How does this work in Europe? And of course the European Union is a treaty organization that binds together the individual member states that make up the European Union. In that way, it is roughly analogous to the relationship of the U.S. federal government to each of the individual U.S. states. So similar to the U.S. system, the EU system is a federalist system. However, the central government, or the body that is set up under the treaties that create the European Union, doesn't have all of the same powers as the U.S. federal government. It is a looser kind of union. And the member states are sovereign nation states within the European Union, not kind of directly the same as the states to the federal government in the U.S. But you can keep in your mind kind of a rough analogy of the relationship of power. So within the EU, in those relationships of power, the way it is divided up in the treaty, each member state, France, Germany, and like, have their own national laws. But then there can be laws adopted at the EU-wide level that bind all of the member states in accordance with the treaties that establish the EU. And the way that works, and there are three different core kinds of international laws, of transnational laws, I should say, that will govern all the member states within the EU. So a regulation is directly binding throughout the entire EU as written. So when we talk about privacy, the General Data Protection Regulation, the GDPR in the EU, is a regulation, and the text of it is law immediately upon the regulation being adopted as written nationally in each of the member states. And so that's a really kind of strong, more central kind of way of the EU doing transnational law. A directive is not directly applicable in the member states. What the directive does is give a set of principles and a set of results that national law has to achieve. And then each member state is responsible for adopting its own national statutes that comply with the directive. So a directive is more flexible than a regulation. A regulation is pretty inflexible. This is it. This is the text. These are the rules. A directive, this is what has to be achieved in national law, and national law then in its own way can implement it. Now, as you might guess, when you're dealing with a directive, there can often be disputes. I mean, Germany might say, hey, France, you have not really implemented in your national law Directive XYZ in the way that the directive says. And in the event of such dispute, there are courts, the European Court of Justice, that can adjudicate and determine whether a member state has properly implemented the directive or not. And then the third kind of is a decision. And a decision really is only applicable to the particular authority, whether it's a state, whether it is some part of a state's apparatus, or whether it is an individual, and they really are more adjudicative kinds of lawmaking or documents. So the core ones that are going to set policy throughout the EU would be a regulation or a directive. And what we're dealing with in cybercrime is a directive. So when you're reading this directive that I gave you to look at, you want to keep in mind these are principles and goals, and each of the member states is supposed to implement them. And within the directive itself, there are pieces of it that flexibility is kind of built in to the directive based on local values. And we're going to be coming back to this again a little later in the semester as we're looking at some different civil liberties issues in cyberspace. Okay, now since we're talking about the difference between a regulation and a directive, and we're going to talk about this EU Cybercrime Directive, let's talk a little bit about how a directive actually becomes enacted into law in the EU. And the first thing you need to have a bit of a sense of is the different institutions within the EU. And remember, when we looked at the US, we said there is an executive, legislative, and judicial function. And similarly, within the EU, there is an executive, legislative, and judicial function. So there is a similar concept of the separation of powers and the function of the different powers, although as we'll see in a moment, the way this is all established and set up is in many ways quite different from in the US. So at the EU level, the executive is the European Council and the European Commission. The European Council is made up of the national leader of each of the EU member states. So, for example, the German Chancellor is also a member of the European Council. The European Commission is made up of commissioners who head the different agencies or different commission branches within the EU that govern different functional aspects of the EU. So, for example, the area of competition is dealt with by a commissioner. And the members of the European Commission are nominated by the European Council. That's this group, right? And then are approved by the European Parliament. So this process, you might want to note, is somewhat similar to the appointments clause in the US Constitution. Now don't worry, we haven't studied that in any detail. I don't expect you to know it in detail. But do know that high-level appointments, executive branch appointments, so the president may appoint a cabinet secretary, which would be roughly the equivalent of a commissioner in the EU, and a cabinet secretary would have to be approved by the Senate. So a similar kind of process. The commissioners are approved by the Parliament. The European Parliament, so now we move into the legislative branch. The European Parliament are elected, the members of the European Parliament are elected directly by EU citizens. And that body of the European Parliament will approve or reject legislation in the way that we will see in a moment. So you have the European Parliament, which you could say is roughly analogous to the House of Representatives in the US. Is there an entity that's roughly analogous to the Senate in the US? In some ways, yes. In some ways, no. So the other body within the legislative branch is the Council of the European Union, or the Council of Ministers. This council is made up of ministers in the national countries, and there are multiple different configurations. There's no set group of individuals that make up the Council of the European Union. It varies depending on the subject area that is being covered. So again, let's say it's a trade regulation, an antitrust issue. So the European Commission on Competition may put forward the proposal, and then the configuration of the council would be, for example, ministers of trade or ministers of competition from the nation states. Those ministers are not elected directly by the people of the European Union. They are appointed and or elected according to whatever process the national law of the nation state supplies. And in many cases, they're appointed, not elected, and they would most likely be appointed by the executive branch within the nation state. So in a very roughly analogous way, the European Parliament is the more populist kind of organ within the legislative branch, and the Council is the more or the less populist branch, but also is not elected directly. And we'll see in a moment how the Parliament and the Council operate together and ultimately must agree if a proposed regulation or directive is to become law. And then there is also a judicial branch composed of the Court of Justice of the European Union and the European Court of Auditors. The Court of Auditors is really dealing just with budget matters. The Court of Justice is dealing with questions of EU law. And so one example that we noted is if there is a directive and the member state allegedly is not properly implementing the directive, then a dispute about that would be heard by the Court of Justice. Here's another graphic, and this is all from the same source, which is a Council of Foreign Relations backgrounder on how the EU works. So the EU citizens directly elect members of the European Parliament. EU citizens elect members of the European Council through their national elections of their national head of the executive branch within the nation, who then make up the Council. The Parliament and the European Council nominate the members of the European Commission. The European Commission is the primary body. There are other avenues through which legislation can be proposed in the EU, but the European Commission is one of the primary ways that legislation is proposed. So the actual legislative proposal doesn't originate often in Parliament, doesn't originate in the Council. It often and typically originates in the Commission. Then the Parliament may, and we will see in a moment, must approve of the legislation, and then the Council, which again is the ministers of the nation states who are appointed and or elected according to the procedures of the nation states, brought together in the Council according to whatever configuration is dealing with the policy issue that is being discussed. And then if there's a dispute as to the validity under EU law, the Court of Justice will hear it. So having looked now at the institutions of the EU, let's really briefly look at how something becomes law through these institutions in the EU. So as we've noted, legislative proposals originate in the Commission. The Commission is not an elected body, and so this is a very unique kind of gatekeeper that doesn't exist in the US system. Now, it is possible for a citizen petition or for a group of the member states or for other European institutions to send proposals to the Commission that the Commission must then consider, but nevertheless the Commission is still serving as a kind of gatekeeper. So a Commission proposal then is given to Parliament for a first reading. Parliament can adopt it as is or propose amendments. Either as is adopted by Parliament or as proposed to be amended goes to the Council, and the Council can then either agree with Parliament's position, and in which case, if the Parliament agree and the Council agree, it is adopted into law, or the Council can say there is need for further amendment and send it back to the Parliament. The Parliament then has an opportunity to look at what the Commission has sent to it. It can either approve it, in which case there's an agreed text and it becomes law, or the Parliament can reject it, in which case the proposal is not adopted and it does not become law. Or the Parliament can decide that there's further discussion needed from what it received from the Commission at the second reading, and can send it to a second reading in Council with some other suggestions for amendment. The Council can approve what Parliament has sent it for the second time, and then it becomes law, or the Council can not approve it, and at that point the text as it stands, with whatever disagreements continue between the Council and the Parliament, goes to a conciliation committee, so to a reconciliation process. And this is a committee of representatives from the Council and representatives from Parliament. If the conciliation committee cannot agree on a joint text, then the proposal does not become law. If they can agree on a joint text, then that full joint text comes out of the conciliation committee and goes back to a third reading in Parliament. Parliament at this point cannot change. There's no more amendment process, and this again is really different than the U.S. I mean, you could have there's no legal reason you couldn't have an endless process of amendment and negotiation within either house and or after a reconciliation process. Politically, it's not really feasible. At some point, something either lives or dies. So here in the EU, the Parliament cannot change the wording of the text at this point. There's no further amendment process. If the Parliament rejects it, the conciliation text, it does not become law. If the Parliament accepts it, it goes to a third reading in the Council. And at this point, again, the Council either accepts it, in which case it becomes law, or does not accept it, in which case the process is ended and it does not become law. So you have there a feel of the kind of bicameralism that exists, even if the Council isn't really analogous to the Senate in the US, but there is this kind of populist parliament and the Council potentially negotiating back and forth for at least several rounds until there either is an agreed text that becomes law or not, in which case it does not become law. Notice that there's no veto option here. Unlike in the US, where the president, the executive, has the power of veto, that doesn't exist here. The executive power is really found in the beginning of a proposal, which comes through the commission, because the commissioners are appointed, at the executive level, and then likewise, to the extent that the members of the council are ministers who are appointed at the national level by the executive, that's a kind of executive check as well. So it's a different sort of checks and balances, and I just want you to have a feel for how that process works, and I want you to have a feel for what the difference is between a directive and a regulation. So now let's look at the EU Cybercrime Directive, which you can see was adopted in 2013. So there's a few things that as you're reading through this, I want you to note. And one of the things when you're reading through this, I'm talking about Article 2, Article 3, so on. Just like reading American statutes is an art that lawyers learn, reading EU directives is also an art that lawyers who deal with these sorts of things learn. And one thing to note that's some ways different from US statutes, in the beginning of the directive, there's these whereas clauses, and these whereas clauses are numbered. The whereas clauses are not the articles of the directive. The whereas clauses are interpretive aids that are giving the reasons and the background for the actual articles, the actual text of the directive. And there's case law and principles within EU law about how to use the whereas clauses as interpretive devices. And the whereas clauses in EU directives and in EU regulations tend to be really extensive, and much more extensive usually than sort of the prefatory clauses or introductory clauses in US legislation. So I don't want you to skip over those things, but I do want you to note that where it starts with the words have adopted this directive, and then it goes Article 1, Article 2, that's the actual text that the member states are supposed to now implement in their national law. So a few things to note. Article 2, the definitions of what an information system is, what computer data is. So notice the difference from the US Computer Fraud and Abuse Act. There's not this language of protected computer that we looked at in the US CFAA. There's not this language of interstate commerce. And that's because the legal authority of the EU to issue this directive is a different kind of legal authority than the authority for the US federal government to regulate something like computer crime throughout the states. So remember, the US federal government, the authority is based on the Commerce Clause in the Constitution. That specific kind of hook or limitation doesn't exist here. There's simply authority to issue a directive on a matter like this that applies throughout the European Union. But the upshot is really similar. Any network computer, any computer on the internet is going to be covered. Notice Article 3, that this statute, like the US CFAA, is an access-based statute, and so it can raise similar interpretive issues to the US CFAA about what access means, and in particular here in this directive, what access without right means, and that's a matter to be implemented in national law and then to be interpreted by the courts. Notice Article 4 that requires member states to have law that ensures that seriously hindering or interrupting the function of an information system is a crime, and this is getting at network interruption, it's getting at denial of service attacks, and it's getting at other sorts of attacks that could cause computer systems, local networks, or the internet not to function. Article 5 deals with deleting, damaging, and so on data. And notice that Article 5 talks about, again, this question of without right. So there's going to be this interpretive question about without right, similar to the interpretive question of access in the US statute. Article 6 deals with illegal interception of information. Now, this really isn't addressed in exactly this way in the U.S. Computer Fraud and Abuse Act, the interception of information. It is true that there are kinds of crimes under the CFAA, access-based crimes, that might facilitate the interception of information, and so that can be a CFAA crime. But we also in the U.S., and we'll get into this in more detail when we talk about the Fourth Amendment in the U.S., the ability for the government to get information in transit is governed by the search warrant requirement. That doesn't apply to private parties. So there are other statutes, the Wiretap Act and the Electronic Communications Privacy Act in the U.S. that create other kinds of culpability if you're intercepting, if you're a private party intercepting another private party's communication, including an electronic communication, without proper authority or authorization to do that. Article 7 is a malware provision, so the kinds of tools that can be used for committing offenses. And the thing that I really want you to notice here is a potential distinction between this provision and the US CFAA's provision about trafficking. So remember we said in the US CFAA, trafficking in a password or similar information through which a computer may be accessed without authorization is a CFAA violation. The tools provision in Article 7 of the EU Directive talks about a computer program designed or adapted primarily for the purpose of committing the offenses named in the statute. So it is clear under the EU Directive that member states are supposed to have provisions that say the production of malware, the coding of malware, the creation of malware, is itself supposed to be a crime if the program, the malware, is created primarily for the purpose of committing this kind of offense. Well, what does that mean? What does primarily mean? Is it possible to have computer programs, computer code that have dual purposes, dual uses? It may be in some cases used for criminal purposes. It may be in some cases used for non-criminal purposes. And that is a common problem in computer crime law and other law that's seeking to regulate the production of technologies that can be used in crimes. If it's a dual-use technology, we don't necessarily want to ban the technology. It might have other really valid, economically and socially valid purposes. If it's a dual-use technology that involves code under a U.S. conception of the First Amendment and freedom of speech, that's speech. So you have further problems with regulating dual-use technology. And arguably, this provision in the EU Directive goes further than this provision in the CFAA, because this is specifically dealing with a password or information that's similar to a password. So that seems like maybe a stolen decryption key. It's not entirely clear that this involves simply the coding or creation of programs, although it possibly could, depending on how you read it. So those are some things that I'd ask you to focus on as you're reading through this EU directive itself. Now there are other EU directives that relate to different aspects of computer crime. There are some proposed directives and regulations that relate to aspects of computer crime, but this directive currently is the core one that relates to the kinds of computer crimes we've already been talking about in this class, relating to economic crimes. So in particular, relating to the crimes covered by the CFAA. We will look over the next couple of weeks at other actions within the EU and within other European countries, countries in the West, and countries outside the West, relating to speech, stalking, terrorist content, as those concern broader human rights issues. Now, for this week in the discussion forums, I'm giving you the option for your initial post of choosing from a number of things. We've covered a few different things in the materials that I gave you to read and in this lecture. So think about the one you could do is the possibility of cryptocurrencies. Should these be regulated because of their role in cybercrime? Is the computer program portion of Article 7 of the EU Directive good policy? Does it go too far? Is there a problem with dual-use technologies? Should the US CFAA be made more clear about malware, being the creation of malware, or is it better to not go into that so much because there are speech and other technological issues we might not want to go into, including, how do you distinguish what's simply useful for malware from what also potentially has other uses, especially when it's being developed? What about these places that are cybercrime hubs, like Romania? Are there steps the international community should be taking? Would they be investigatory steps? Would they be criminal law steps? Could there be other social policy steps that might help mitigate kind of the problems that lead to people getting involved in cybercrime? And then another one you could pick up is what are other things the US and or the EU or other parts of the international community could be doing, or maybe in your view ought to be doing, in relation to Russian-based organized crime. So you can pick up any one of these for your initial post. Remember, you still do have to do a response post. You can do a response post to anyone, so you don't have to do your response post in response to something that you did as part of your initial post. You can if you want to, but you can also pick another one and it'll give you a chance to discuss some of the other topics that come up this week. So I hope you enjoy the materials for this week. Hope you have a great week, and I will see you online this week, and then I will see you in person next week.